Hello, I'm Frank Hartman with the Hartman Law Firm. I'm a practicing attorney in Charleston, South Carolina, specializing in auto accidents and personal injury. And today we're answering the question, what is a mediation? There are 3 points that I'd like to cover today in today's video. The first of which is, a mediation is non-binding in nature. And what I mean by that is, essentially, you and, let's say this is in the context of your auto accident case, you and the defendant, as well as your two respective lawyers, are going to be put into two different rooms. And there's going to be a person called the mediator who goes back and forth between the two rooms and attempts to resolve whatever matters you may have that are currently keeping you from being able to settle the case, whether that's a liability issue or it's a value issue or something else that goes beyond the scope of what we're talking about. And the idea behind non-binding is that it's essentially a discussion where you can sit down, you can haggle, and you can talk over all the issues. And in the event that you are unable to resolve your issues at the end of the process, essentially you can walk away from the table, but you walk away from the table with more information than you had before, and you have a clearer sense of what the central issues are that you need to be working on as you move forward. The second thing that I would like to describe is the actual process in which a mediation takes place, because it's kind of an interesting process. Typically what you're going to see is that the plaintiff is placed in one room in a completely different part of the building, and the defendant is placed with their respective attorneys in another room. And the mediator will go back and forth between the plaintiff and the defendant, essentially communicating what the most recent offer is or what the most recent variation on the terms are. And in doing so, what you're able to do is take a lot of emotion out of the process of negotiation. And that can be a real hindrance when you're trying to get something resolved, because everybody feels like they're in the right, everybody wants what they want, and they bring their emotions to the table. But when you take them and you physically separate the two parties, you're able to take a lot of that emotion and put it aside and really bring it to essentially what the issues are that you're trying to resolve. And in doing so, a lot of times you're able to resolve things that people really, coming into the process, really did not think that they were going to be able to resolve. And in that respect, mediation is a very important tool in today's judicial system, which brings me to my third point, that the judicial system favors mediation. And in fact, in most counties in the state of South Carolina, mediation is going to be required both in the context of family court issues, personal injury issues, and specifically medical malpractice issues. It is required. It's something that you actually have to go to and go through before you can actually get in front of a judge. And the reason why they do that is because from an administrative point of view, the courts are overwhelmed with the number of suits that people were bringing against one another. And this is a way of reducing that number from an administrative perspective. And more to the point, it's a way of keeping the cases that actually should be in court, they'll make it there eventually. If there really are issues that need to be litigated, they will be. But this kind of weeds out all the ones that don't necessarily need to be in court, but people were pressing for litigation because their emotions were driving their decision making. I'm Frank Hartman, and today we answered the question, what is a mediation? If you're watching this video and you have questions, I would encourage you to pick up the telephone and call me at 843-300-7600, or feel free to look me up at thehartmanlawfirm.com. Thanks for watching.